Hello YouTube, I'm Vince White. I'm an employment attorney. It's 10 p.m. It's 10 p.m. and I still gotta go to the gym because this blood pressure's not gonna take care of itself. But on this channel, I'm an employment attorney and we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from Kathy Sue. And Kathy Sue, I'm not making fun of you, which is like a crappy way to start a video. Because it makes it sound like I'm going to be making fun of you, but I'm not. I'm going to read your question, which isn't really a question. It's just kind of like a statement. You call it a sample, and you're discussing your potential claims. But I want to highlight it, and I want to read it into the record here, because this is how a lot of people approach employment attorneys. And gotta be honest with you, it's why some folks have a hard time getting representation. Kathy Sue, not your job to know these things. Not giving you a hard time. I'm no doubt in my mind you're incredible at what you do. But you don't, I think, do what I do. And that makes sense. Why would you, right? Listen, quality of life for employment attorneys, horrific. Compensation, not bad. But quality of life is not great, right? So like, I think you're probably happy you're doing what you do. I'm just saying, I don't know how to approach a rocket scientist. I don't know how to approach an electrician. I don't know how to approach a laser tag combat arena designer. I don't know how to approach any of these people, right? And I don't know how to approach you and what you do. I don't know the lingo of your industry, but I do know the lingo of this industry. And so I'm going to use your sample that you provided as kind of an example of like what is good and useful for the employment attorney to hear, and what is like maybe a keyword that like makes employment attorneys just like tune out. Here we go. And if this annoys you, it was not my intent, Kathy Sue, and I hope that you will forgive me, because this is sincerely meant to fine-tune you in talking about your case, but also other people when they're talking about their case. And I think that we can help a lot of people, you and I together, by engaging in this. So it's going to sound like I'm being shitty, and maybe I am, because I'm a shitty person, but that's not my intent towards you, if that makes sense. Like, you, I think, are going to help a bunch of people, and I think that you are communicating really well and doing everything right because you don't work in this industry. All right? It's quite a disclaimer. All right, here's what Kathy Sue, YouTube user Kathy Sue, had to say. Sample, : I filed a whistleblower, disability harassment, and put them on notice for my mental health issues. And we're going to go, I'm just going to read the whole thing, and then we're going to go through the whole thing and give comments. They failed to process my FMLA, which was FMLA inference. I assume you meant interference. Typo. Did not follow the ADA interactive. I assume you meant the ADA interactive process. The reasonable accommodation dialogue, and did not offer reasonable accommodations. They immediately moved on pretext to fire. Set deadlines they knew I could not meet. Gave me new assignments with no training and short deadlines. I can prove that I only met deadlines half the time and never written up, but after my whistleblower they were suddenly scrutinized. Assigned work that the agency had not performed and would never perform. Call a risk assessment and audit. The whistleblower was notifying of agency's high risk due to policy violations. Whistleblower and harassment allegations were never investigated. Hostile work environment and retaliation allegations. Hostile work environment and retaliation and disability discrimination never investigated. The only investigations were for my pretext performance issues. It was capital punishment, not at will. Okay. So first off, I think you were tired and frustrated when you wrote this, so I'm not trying to give you crap about the typos. We've all been there. Not playing that game. Not at all. 100%. It's the internet. We type fast. Probably the wee hours in the morning. You're probably exhausted after the long day of fighting with these people, and I get it. Now, let's just go line by line. I filed a whistleblower, not a claim. Not immediately. You're just saying things that make employment attorneys go like, oh, I'm tuning out. Whistleblower, god damn it. That's almost never a claim. Could be a claim. Immediately somebody's jump in the comments and be like, whistleblower's a claim. You can have whistleblower claims. Totally can. Totally can. whistleblower claims are often higher risk, can be lower value, usually are lower value. Not always. Sometimes they're incredibly high value, right? Sometimes they're incredibly valuable. Don't get me wrong. But generally speaking, whenever somebody approaches an employment attorney with a whistleblower claim, that employment attorney is hoping they mean retaliation. Because 99% of the people who approach employment attorneys with actual whistleblower claims are just time wasters, right? And employment attorneys, many of them are answering their own phones. This week I answered many of my own phones. Boy, is that exhausting, right? And when you're answering your own phone and 99% of the time people call you up with whistleblower claims, and you know that 99% of those claims are adjunct claims for people who will not get off the phone. Like, you're just like, listen, not into it, can't help you. Gotta let you go. Bye now. And they're like, no, but you're wrong. You're wrong. It's $1 million case. Okay. Maybe. Yeah, you should go hire someone else who believes in you to bring your case, right? And they'll sit on the phone and argue with you, and you have to stay on the phone and be nice with them because they might give you nasty reviews or file grievances if you get them off the phone too quick, right? Because the bar associations aren't interested in the realities of practice, where sometimes you're going to be like, listen, can't help you. Don't care that you're screaming at me. Gotta let you go. Bye now. Right? Like, that's just the reality of life. But the bar association will be like, no, you're being mean to that person. You're being cruel. You should have stayed on the phone and told them that you cared about them. Okay. You don't do that. Like, I've heard calls when people call the bar association looking for referrals, and the bar association basically tells them they don't give an F about them. But I guess that makes sense. Why would the bar association hold itself to the standards it holds attorneys to? That wouldn't make any sense. Anyways, I digress. So, right off the bat, you start off with something that just makes employment attorneys generally tune out. I filed a whistleblower. Everybody tunes out. But wait, it gets better. Because you then say, comma, disability harassment. That's a claim. That's a claim. Let's talk about that. Okay. And put them on notice for mental health issues. Great, you reported a disability. So you have a disability discrimination issue, and you notified them your disability, so they're on notice. That's positive. You go on. They failed to process my FMLA, which was FMLA, and I assume you meant interference. Also a claim. FMLA, that activates an entire statute, the Family Medical Leave Act. That's a federal law, separate from the ADA, the American Disabilities Act. We now have two statutes at play, two sets of federal claims, not even getting into the state and local claims that may potentially be in play. You go on. Did not follow the ADA interactive. They didn't engage in the reasonable accommodation dialogue. They didn't engage in the required interactive process under the American Disabilities Act. You have a good grasp of the law, Kathy Sue, and that's one of the reasons why I highlighted your question, because your grasp of the law is unusually high. You know, you've done research. You have a good understanding of this field, and you're still not pitching your case the way I'd recommend. You know more than most. Clearly, you're intelligent, well-read, you've done the research, you put in the time, and we're still hitting some bumps. That's really important to know, right? Like, think of how good and talented you are compared to the average Joe coming to this field with no knowledge. It's incredible. You're doing great. But we can tighten it up. We can make this pitch a little bit better, all right? So they immediately, I go on, and did not offer reasonable accommodations. Great. So you understand, under the ADA process, they both need to engage in the interactive process, the reasonable accommodation dialogue. They have that duty. And they also need to offer you reasonable accommodations if such a reasonable accommodation exists. You highlighted they failed in both ways under the ADA because your understanding is effing great. You have a great grasp of this law for a non-attorney. Frankly, you've got a much better grasp of this entire field of law than any attorney in any other field unrelated, right? Like, if you pitch a personal injury attorney on this, they'd be staring at you like, what are you talking about? Are those things? Are those protected? Like, are those claims? I don't know. You got it. You got it down. You're killing it. We're going really well. So you go on. They immediately moved on a pretext to fire. All right. Pretext. Great. I would probably reframe that as in I asked for an accommodation. They messed with my FMLA, and then they fired me, right? We can get into that they fired you on a pretext. That's key, but I don't know if it's the lead in your pitch. but that's fine. It's actually pretty good. You go on. Set deadlines they knew I could not meet. I wouldn't lead with this. You're describing the pretext. You're still doing a great job. Gave me assignments with no training and short deadlines. Still doing a great job. You're describing the pretext. I can prove that I only met deadlines half the time and I was never written up, but after my whistleblower, they were suddenly scrutinized. Whoa. What the hell, Kathy Sue? No offense. So basically you're like, listen, I can prove that I only met the deadlines half the time. Why would I want that? That makes you sound like a terrible employee. Like, I get what you're saying. You're like, listen, I never met deadlines before, and then I engage in some protected activity, and all of a sudden it matters. I never met deadlines. Sure. And that may be an argument you ultimately settle on. But think about the optics of that argument in an elevator pitch to sell your case to an employment attorney, which I know you're not doing, right? Like, I know right now in this post on the internet, you're venting a little bit. You're engaging in, conversation with like-minded folks here on the channel. So I'm not faulting you. I'm just saying, like, whoa, that's not a leading bullet point in our pitch about our case. I blew half my deadlines. Okay, let's slow down with that. Let's take it easy with that. That's not great. Now, again, you may be right. That may be the leading argument. Like, hey, we weren't held accountable for deadlines before, and then after I reported my disability, I was. That could be a great argument. It could be the best argument. It just probably isn't the pitch bullet point. It might be that once the attorney is engaged with you, once the attorney is like into it, listening to you, really engaging with you, really excited about helping you, that you're like, okay, so here's the deal. They're going to say that I didn't meet deadlines, but the reality of the situation is nobody was held accountable to deadlines. And all of a sudden, I engage in some protected activity, and I'm the only one who's held to deadlines, right? You can see the difference there a little bit? Okay. So, assigned work that the agency had not performed and would never perform. Don't know what that means. And people routinely say this stuff to employment attorneys, and you know what that means. You know what that means. Like, first off, we don't know what your agency is. We don't know what your field of work is. We don't know what the work assigned was. Listen, it could be that your company paves driveways. You work for a paving company, and they pave driveways. And then this company just assigned you to build a nuclear reactor. Clearly, you and this company are never going to build a nuclear reactor, right? Those are two different things. The company paves driveways. I suspect you're not going to figure out fission, nuclear fission. Is it fission or fusion? I believe it's fission. You're probably not going to be splitting the atom in a controlled fashion when your expertise is paving driveways. Like, those are two different fields, both of which have complexity and require a depth of knowledge, certainly. But they're very different, right? But here, your statement, we lack context for, and it makes it tantamount to gibberish to us. Assigned work that the agency had not performed and would never perform. Okay. What do I do with that? Now, I know, gathering context clues, that you mean, like, listen, they gave me work that this whole agency I work for, nobody in it could do. It's part of setting me up to get me fired. But that's more meaningful, that's the pitch. They gave me work that nobody in the company knew how to do, because they knew I couldn't do it, because nobody knew how to do it. And we don't do that work. So it was clearly meant to just make me get set up to fail and get fired. So you're giving a little more hand-holding for the attorney there. We're just attorneys. We're not rocket scientists. We're not brain surgeons, right? So a little bit of hand-holding can really help the case move forward, right? A little sugar makes the medicine go down. Was that Mary Poppins? Perhaps? Supercalifragilisticexpialidocious? I don't know. All right. Anyways, we go on. Call a risk assessment an audit. Even with context clues, I'm grasping at straws here. I think what you mean is they sent somebody in to do a risk assessment and like turned it into a negative review for you, like an audit of your efforts to make you look bad. That's what I suspect you mean, but like I'm guessing, right? The whistleblower was notifying of agencies high risk due to policy violations. No idea. No idea what we're talking about. And that's fine. I know that you know what we're talking about because you lived this, right? So this statement makes sense to you. I didn't live this. I don't know you. I don't know your agency. I don't know your employer. I don't know what you do for a living. I don't know what happened. I have some vague idea. Listen, sounds pretty much like you reported disability and they went after you hard. You tried to take some time off through the Family Medical Leave Act and they messed with that process and went after you even harder. That's what I understand, but that's all I understand now. That's what I've taken away from all of this so far. The whistleblower was notifying of agencies high risk due to policy violations. I guess what I take away from that is that your agency was violating some policy set by someone. Internal policy, external policy, federal policy, could be federal policy, state policy, local policy. Who set the policy? Are you at fault for the policy? Are they at fault for the policy? Like, what are we talking about here? Whistleblower and harassment allegations were never investigated. Okay, so again, and these are, so whistleblower is just a way of like tuning out attorneys. We've established that. Whistleblower and harassment. Okay, so harassment is another key word to tune out attorneys. Sexual harassment, employment attorneys are all about that. The ears are up. Full interest in sexual harassment. Discrimination, we're into that. That's how we make money. We can turn the discrimination claim into money for you. And we make you money. We make money. And we like money. Even when we're monsters. If we help you, we make money. So, we want to help you. Even if we're the worst person. And if we're not the worst person, we want to help you. And then we also want to make money. Because we're both good people who have a deep sense of greed. Right? Nothing wrong with that. You're helping people and you're making money doing it. I feel like we're in a chapter of to have and have not. Okay, going on. Hostile work environment and retaliation and disability discrimination never investigated. Great sentence. I don't love hitting attorneys with hostile work environment because that can be a little undefined and a lot of people misuse the phrase hostile work environment. However, that's not your job to know. That's more in the realm of like, we're close. We're close to the bullseye. We're in the realm. So like, great sentence. Excuse me. The only investigations for my pretext performance issues. Also a great statement. They refused to investigate all of my claims. I complained about very valid issues with discrimination and FMLA retaliation, and none of those things were ever investigated. But they sure had the resources to look into why I couldn't do the work that the agency doesn't even know how to do. They had the resources to look into why I didn't meet my deadlines when those deadlines were crazy short and nobody could have met them. Right? Like, I get it. I get what you're saying there. That's great. And it's in the right place. It's at the end of your pitch. So, like, it's kind of explaining away a slight hitch in the pitch, right? Like, it's a hitch in the pitch. It's not like, you never want to be like, oh, man, I missed a bunch of deadlines. And that's fine, because it's not fine, right? That could be a real problem, a real complication, a real risk factor in the case. But here, you're at the end of the pitch, you're like, okay, listen, there is a termination, but it was pretextual, and here's the deal. The deadlines were wild, the work was stuff we don't even do, and they just kept pouring resources into looking into it and papering those pretextual terminations instead of investigating the really very, very sincere, very real complaints I made about discrimination, failures to accommodate, and FMLA stuff, right? So you're crushing it. Everything about that's perfect. It was capital punishment, not at will. It was capital punishment, not at will. I think what you're saying, I think this is an emotional outburst. You're saying, like, listen, that was not at will employment. It was so bad it was capital punishment. And I don't mean to quote Bachelor Party? Is that the movie? There was a gentleman in that who was probably a racist trope, frankly. But he would say things like, but did you die, though? And here, you're saying, it was capital punishment. And part of me wants to say, but did someone hit you, though? Because I suspect they didn't. Like, I get it. You're trying to, like, it was worse than at-will employment. And I don't think at-will employment is necessarily a bad thing. It's the law of the land, and every job I've ever had was at-will, and it's never bothered me once. But you're saying it was worse than at-will. It was capital punishment. Okay, so who hit you? Where'd they hit you? What'd they hit you with? Nobody hit you? So why'd you say that? Right? Like, I get it. You're frustrated. It was bad. You're mad. You should be mad. You've been wronged. Like, this is a claim. You clearly described a variety of claims here. You were horribly wronged. But you're not. You're not crazy, but you're set. Also, I've recently been taught that I shouldn't use the word crazy in this sense. You sound a little over the top. You're overselling a little bit. Who hit you? Nobody hit you. Somebody hit you, call the police. Also lead with that. Can you imagine? I asked for a disability accommodation, and they got out the beating stick, and they just started wailing on me. It was a bamboo cane, and I had blisters on my back. They brought in a professional torture engineer to just beat the heck out of me. And that's what happened, and it was horrible. We'll lead with that, right? If we're really talking about capital punishment, if this really happened, if we're delivering beatings to adult human beings, don't bury the lead. Get it up top. But I suspect we're not. I suspect you may have gotten a little carried away and wanted to express just how bad you felt things were. But it's not great. It's not great. It kind of makes people wonder how bad things were in reality. There's capital punishment. Oh, who hit you? No, nobody? Okay. Was everything else you said also bullshit? And I understand. You're trying to give color, right? You're trying to fill us in a little bit. I understand what you're doing. I understand why you're doing it. I just don't think you should be doing it if you're pitching an attorney. And I understand, Kathy Sue, that you were not pitching an attorney. You were giving us a sample. You were venting here. But it felt like a pitch to an attorney. And that's why I zeroed in on this. Because I think this is how many super talented, super intelligent people communicate to prospective employment attorneys when they're very, very frustrated. Like, I cannot stress enough. I can tell. You got this. You understand this area of law. I have had associates who were assigned to me when I worked at other firms who understood this area of law far less than you do. Sincerely. I can tell that. I can tell it from reading what you wrote. But you're upset and you're pissed. And this paragraph is 50% awesome in terms of like pitching an attorney. And the other 50% is like, I would like you to not take my case. And I would like to do everything in my power to ensure that although I have a fantastic set of claims, and it really sounds like you do, even though I have a fantastic set of claims, I just want to make sure that I don't get out of my own way. And I want to make sure that I can obtain representation. And I know that sounds like I'm poking fun of you, but I'm not, because it's not you. It's the norm. Because you've been wronged, and you're frustrated, and you're mad as hell, and you don't want to take it anymore, and you want to tell someone about it. So when you get the attorney on the phone, it all comes out. I get that. That's human nature. That makes sense. It's just not the most effective thing for you if you're trying to obtain representation. I hope this helps. Kathy, I hope you forgive me. I sincerely cannot stress enough. I can tell from what you wrote here that you are a good, intelligent person with a great grasp of this field of law. And that's why I picked this. If this helped, like, subscribe, comment down below, share the channel so it can grow. And just think about these things when you're pitching your attorney. I'm going to throw this in a Find an Attorney playlist because I think it's going to help some people. And take care out there, everybody.